Good afternoon, everybody. It is afternoon, right? Thank you for being here. As most of you know, my name is Wes Kaufman. I'm one of the partners with Heartwood, and we've got I think, a very critical, may not be the most exciting topic, although to Leah, it's very exciting, but it's one that all of us are going to be touched by at some point, right? Just as a show of hands, who here has a will? Okay, everybody, awesome. So you have all named somebody as an executor, right? So we're going to talk a little bit about that. Who here is named as an executor in a will? Okay.
That you know of.
Yeah, that you know of. Yeah. Who here is actually settled in a state? Okay, oof. So you people have had some fun, yeah. So we're going to talk about all that stuff today. That's great. It's pertinent. Everything we're going to talk about is pertinent to everybody here today. We're joined by Leah Henschen. She is a director of estate settlement at Virginia Trusts and Estates.
Virginia Estate and Trust Law.
Virginia Estate and Trust. Thank you. I get those. I always get it backwards because I think VATE
right.
And I think VATE. Virginia Estate and Trust. And she's been doing this for 20 plus years. She's got a wealth of knowledge and stories and wisdom on the estate settlement process. So we're going to sort of have a fun conversational walk through this, and then hopefully that'll be 30, 40 minutes, and at the end we'll open it up for specific questions you all may have. And as always, I think Leah will be happy to hang around afterwards and answer any offline questions as well. So.
Sure.
Without any further ado, we're going to get started. So let's grab a seat here. So just to start off, tell me a little bit about yourself and what you do and how you go about helping people with the estate settlement process.
Sure. So as Wes said, I've been doing this for about 25 years now. Even before I went to law school, I worked in fiduciary administration, so trust and estate. I'll try and speak up a little bit. So I've been doing this for close to 25 years. And I've done it in all different settings, so big banks. I had my own small practice for a short time, and now at Virginia Estate and Trust Law, I lead our estate administration practice. So I've seen a lot of estates and trusts, and good, bad, all of it. But even coming out of law school, it took me a long time to realize that this was really my passion. I thought, I want to do something where I'm going to help people and where I have all these other interests. Maybe I can be an environmental lawyer. But it's taken me all this time to realize that this is actually where I help people the most. We help clients who are settling estates, maybe very small estates, all the way up to very large, complex, taxable estates. Every facet of estate administration we help them with, and we help them in different capacities. So, they might just come to us for an hour consultation, or they might say, you do it all, and our firm can serve as the actual executor if they choose not to do it. So we work in all different, we can meet them wherever they are, whatever their needs are, we can help. My practice, I think, so as a trust and estates attorney, a lot of people will be maybe like 90% estate planning, 10% estate administration, and I'm really the opposite. So because this is my passion, I do about 90% administration, and I still do a little bit of planning, but it's about 10% of my practice at this point. So a little bit about me.
Okay.
Yep.
So I don't know if you guys if anybody here has ever tried to find somebody to help with estate settlement or help you be an executor, but Leah's kind of a unicorn, I think, because most people don't want to do that work because I think it's just, I guess whatever reason, it's work that lawyers don't want to do. So she is a treasure that we've found. So I'm going to start, we'll kind of have to see this flow. So let's say I've just updated my will and I've named an executor in it. What are some things that I can do to make sure that person's job is as easy as possible when it comes time for them to do their job?
So I always look at estate administration as sort of pre-death and post-death, right? Pre-death, we've done the plan. And for a lot of us, like, we sign our documents and it's just like this weight lift off our shoulders and we think, we're done, right? You put that binder on the shelf and you're like, I did my job. But really, most good estate planning lawyers are going to give you some homework. And so they're going to give you a list of things that you need to do, whether it's retitling an account or updating beneficiaries on an insurance policy or an IRA. They're going to tell you what you need to do, right? So the number one thing that makes your executor or your trustee's job the easiest is follow those directions that you've been given by your planning attorney. Don't just put that binder on the shelf. Look at it occasionally. I know it can be painful sometimes because you really don't want to look at it anymore, but it's good to think about it. If you have new grandkids, if other people pass away in your life that maybe have a part in your estate plan, update the documents, go back and look at those beneficiary designations again and make sure everything still makes sense based on the new information. So number one, follow the instructions. Number two, don't just let it be a static thing. Update it regularly, look at it regularly. And that doesn't always mean you need to go back to your attorney and make changes. Sometimes it just means like you just literally look at it and say, has anything changed? Does this still make sense? Every estate planning attorney is going to say, come back and talk to me every 3 to 5 years. The law changes, your situation changes, and that's good advice. But sometimes that's not necessary, and you can just look at it yourself and say, it's the same. We're good, right? So I think those are the two big keys: following the directions and just don't let it be a static thing. Update it regularly.
So typically, in our world, as it relates to you all, the retitling of assets and or adding beneficiaries to accounts is something that usually gets mentioned and that we need to do when somebody is updating and working on their estate plan. And if you could speak specifically, so what, because we talk about probate, non-probate assets. So retitling, how does that help in the process, or adding beneficiaries to accounts, transfer on death?
So one thing that a lot of people are trying to do when they're doing their estate planning is avoid probate, right? And so when we think about probate, the assets we're talking about are assets that are in the decedent's sole name, that don't have a beneficiary designation, that weren't owned jointly. So just things so if I die, anything in the name of Leah Henschen is a probate asset. So we want to limit those probate assets. So one of the things we might do, and every situation is different, so follow your own attorney's advice, right? But we might add a joint owner. We might, if we've set up a revocable living trust, we might retitle the assets into the trust. We might look at our everyday checking account and say, ooh, this has gotten over $75,000. Let's add a beneficiary so that if it does end up in my sole name at my death, it has a beneficiary that drops it into my trust or makes it go directly to the next owners who I want it to go to. So again, each situation is going to be different. Everybody's plan is going to look a little different just depending on who your people are, what your assets are. But the titling really matters for what we're trying to do. We're trying to keep it as simple as possible at death and also as cost effective as possible. So the titling and the beneficiaries matter a lot.
And then typically, just for everybody here that may not know, why do most people want to avoid probate?
So probate, when we go through probate, so what we're doing is, if there's a will, we're recording the will. If there's no will, then somebody is going to the courthouse and qualifying. So you'll have either an executor or an administrator who's going to settle the estate, the assets, the probate assets that are in the decedent's sole name. So if I haven't changed my added beneficiary designations, or if I haven't retitled my accounts, and I have $2 million in my name at my death, then I have a $2 million probate estate, and somebody has to go to the courthouse, qualify as the executor, and collect those assets into an estate account, pay bills, pay debts, all the things that you need to do when you settle an estate, and then distribute those assets according to my will, or according to intestacy law, if there is no will. So probate in Virginia is a little bit of a headache, not something we can't overcome, and we do it every day. But it requires, there's a commissioner of accounts in Virginia in every locality that oversees the probate process. So whoever's qualified as the administrator or executor, they have to report to that commissioner of accounts on everything that they do. So they start by filing an inventory. Here are all the assets in the estate. They also file an accounting every 12 months until that estate is closed, and it's a very, very detailed accounting that says exactly every penny in and out of the estate, where it went, why you paid it there, and you have to have receipts and invoices and copies of canceled checks to show that what you did was proper. And so the commissioner is going to look at that, your accounting that you filed, and sign off on it, and then file it with the court saying they did their job. That process of filing that accounting is where a lot of people get really hung up. And it can just be a super pain in the neck. So, you know, it happens every day. Sometimes people just forget about an account that they had that their mom set up when they were 12, right? Or something like that, and it's grown over time, and all of a sudden there's a probate estate. Or people, you know, things happen. They sign their documents, and then they get very sick, and they can't take care of the titling or the beneficiary designations. A lot of unexpected things happen, and we end up with probate all the time. It's a tedious process, and you know, a lot of people will come to us during the probate process and say, I need help, I can't do this. You know, once they qualify, they get this letter from the commissioner of accounts, and it tells them, some people think it's a very scary letter. It tells them all the things they can do and all the things they can't do and all the things they must do, and they just kind of get scared. And so, you know, we'll help you through the probate process if we need to, but that can get expensive. Like, you don't want to pay me to do that probate process if we can avoid it. So probate in Virginia can be difficult.
Yeah, and the other thing, I think, and correct me if I'm wrong, about probate is everything that goes through probate becomes public record, right?
Exactly.
So it's if anybody wants to go to the courthouse and request, you know, a copy of somebody's estate that's been probated, they can see that, right? So a lot of people want to avoid probate for privacy reasons as well.
Good point.
Right?
Yep.
Yeah. All right. So I've just completed my will, named somebody as the executor. Do you recommend letting that person know that they're the executor? I'm guessing yes. And also, what steps should somebody take so that executor, again, has, we talked about the titling and all that, that's great, but you know, as far as just practical things so that the executor has an easiest time as possible.
Yeah, so if you're comfortable and you can do it, I highly recommend telling your executor that you've named them. I mean, and even sometimes before you name them, just talk to them and make sure that they're okay with that. It's one of the hardest things when you're doing your estate plan is figuring out who those people are, right? Who those executors are, who can serve to carry out your wishes. So maybe you don't have a lot of options, but if you can get their buy-in early, then you know that you can maybe have a level of comfort that they're on board, they want to do this, they're happy to help you, right? So if possible, I would definitely recommend telling them that you've named them. It also sort of, as soon as someone dies, everybody starts to panic a little bit, and you know, having someone who knows they're supposed to be in control kind of helps everybody just breathe a little bit easier. So if you can, tell them they're your executor, but tell them more, right? A lot of our accounts today we do everything online, so we don't even have printed statements that tell people where our assets are. So tell them where the assets are, tell them, you know, who they need to call, who's your CPA, who's your financial advisor, who's your attorney. Tell them who they need to call. Most attorneys most estate planning attorneys that do this, as the main part of their practice, will give you a binder. And in that binder is a great place to put all this information, right? Print out a copy of a recent statement, and at least that gives them a starting point. And have some contact information in there for people that know your financial situation and can help you. We work with our financial advisors all the time when someone has passed because they tend to know the details of the assets. It might not be a perfect picture, but at least we know where to start. So tell them where the assets are. One of my favorite estate administration stories is a guy came to me one time and he said, well, my dad just passed away. Everybody keeps telling me there's gold and silver. I have torn the house apart. I cannot find the gold and silver. And I was like, well, what about a safe deposit box? Where did he do his banking? No safe deposit box. I've called every branch in town. I cannot find it. And he says, all I found is these papers. And so there are these little diagrams. There's like a rectangle and these measurements. There's like a little square here and some stars. And so I'm like turning it around and looking at it, and I said, so when you stand in the back door of your dad's house and you look in the backyard, is there a shed here? He said, yeah, I think there is. And he said, I said, well, is there like a tree here and maybe a tree over here? Yeah, exactly, that's exactly right. I said, go find the gold and silver in the backyard. And he literally found over $1 million worth of gold and silver buried in the backyard. What if we hadn't figured that out? Like there was a literal treasure hunt in this estate. And if he had just told his son, hey, when it's time to settle my estate, the gold and silver's in the backyard, would have been a lot better. Thankfully, we figured out that mystery. But so tell people about the assets. Tell people where the documents are. Sometimes a will go missing. And in Virginia, we have to have the actual wet-signed original will to record at the courthouse. I recommend do not put it in your safe deposit box because sometimes it's very hard to access the safe deposit box after you die. Put it somewhere safe. We've seen wills in freezers before, so maybe not the freezer, but just somewhere safe in the house. But tell your executor where it is so they know where to go find it so they can record it if they need it. So give information, and if you're comfortable, talk to them about it. Talk to them about people, maybe some difficulties they might have dealing with certain people that you've named in your estate plan, and if you have suggestions for how to deal with those people, try and as comfortable as you can be, or if you're comfortable, as forthright as you can be, it serves everybody really well.
Yeah, it's great advice. We've had situations here where people have come to us and said, I just found out I'm an executor, had no idea, and my relative died, and what do I do? So the more information that you can share with your executor, it's going to make things so much better. And you mentioned something there at the end that's key is let them know where the documents are, in the house, because when this happens, the last thing somebody wants to do is have to go, turn a house upside down in the middle of everything else that's going on. All right, a couple questions. So again, I've been named executor. How much authority does an executor actually have? And on the flip side, how much liability does an executor have?
So most wills are going to give you the standard powers in Virginia, fiduciary powers, that are listed out in our code. And if you have those powers, even that code section reference, that's going to give you most of the powers you need to deal with the property, to pay debts and expenses, to hire people to do things. So you have a lot of power derived from that statute. If we don't have a will, you don't get those powers automatically. You have to petition the court to get those powers. So just inherently, you generally have the power to deal with the assets, to take them in, to distribute them out. That's just the nature of the job of being an executor, right? And then if you have that code section, you have additional powers that can give you some flexibility in how you do your job. Your job is to find the assets, bring them into the estate, pay the bills, pay the debts, pay the expenses, file all the tax returns that need to be filed, make sure there's no remaining liabilities to be paid, and then distribute the assets to the beneficiaries according to the terms of the will or according to intestacy laws. So one of the places, we see this more in insolvent estates. Well, it's really only in insolvent estates, but you'd be surprised sometimes when you do have an insolvent estate, even people you wouldn't expect, sometimes their liabilities are truly more than the assets. Personal liability arises for the executor or the administrator if they pay debts out of order and there aren't enough assets to pay everybody in the correct order. So truly personal liability will arise if you do it in the wrong order. Or if you pay the wrong beneficiaries and they aren't willing to give the money back and give it to the right people, you can be personally liable for sending assets out where they don't belong. So there are some protections that we can sort of put in place to help with the personal liability aspect of things. But really, you know, I think one of the big things is getting some good advice, especially if you don't know. Like, let's slow down, see what things are, get some advice, and then make your payments or your distributions. But there definitely is potential for personal liability sometimes. And generally, the powers you have are those that you need. But if you need more powers, sometimes we have to go to the court and get those.
So that prompts a good follow-on question. And this is probably, there's not a concrete answer to this, I'm guessing, but so do your best. But sort of at what level or what complexity of an estate do you recommend, you know, going out and finding somebody to help, whether it's someone like yourself or a CPA or a financial advisor or whatever it may be? So
I think it's very important to seek advice in every situation and early, right? Because so many times we can start down a path that maybe we didn't have to go down at all, or start down a path and really we should be going down a different path. So, and like I mentioned from the start, sometimes it's just a consultation with a lawyer. It's a 1-hour thing. You get the advice, you get the direction you need, and you're off and rolling. You can handle everything on your own. So it's not that it has to be, you know, big, expensive, ongoing assistance, unless you want it to be. But I think that it saves a lot down the road to go and get that initial consultation, get set on the right path, and then, you know, roll from there. A lot of times what we see is somebody's, you know, you're in the middle of grieving, you've lost a loved one, and you just start. You're like, it just helps you feel better, like you're doing something to go ahead and start settling the estate. But so somebody will go to the courthouse and qualify, and they're like, okay, I'm qualified, now I can do it. They don't really know what they're doing, number one. But number two, sometimes like the assets in the sole name, those probate assets, if they're less than $75,000, they could have been dealt with in a much simplified manner. So in Virginia, we have a small estate procedure that if, like I said, if the assets are less than $75,000 that are in the decedent's sole name, you can use an affidavit to collect those assets without having to qualify for a probate as executor or administrator, without having to report to the commissioner. So avoiding some of those headache type things that you would otherwise have to do. But many people don't know about that, and so they go and qualify, and once they qualify, it's too late. Now you're you're qualified, now you gotta report to the commissioner, you have to tell them all the things, you have to give them their inventories, their accountings, and everything that they need to see. So I think the earlier you can go and see someone, the better. I'm not saying it has to be in the first day, in the first week even. A lot of people think they need to rush and just go and do things, but if you can take a step back, slow down, Like the debts aren't going anywhere. The assets are hopefully not going anywhere. Some things you might need to protect, right? If there's been a caregiver in and out of the house, you might need to change the locks to protect the assets pretty quickly. But otherwise, the assets are going to be there, and you know, it's not, you don't need to rush. So just take your time. When you're ready, you can go talk to an attorney and get your path straight, and then act.
I think that, yeah, I think going for advice is sounds like a key, whether it's seeking someone like yourself or calling us who can point you in the right direction, or calling the attorney that did the will. Sounds like a great first step. So you talked about taxes. As an executor, what kind of tax returns need to be filed, and how do you go about doing that?
All right, so one of the most common questions that we get is, if somebody's receiving an inheritance, do I have to pay tax on this? So it's not a simple yes or no answer, but I look at it as sort of three different types of tax responsibilities as the executor. Number one, the decedent had their normal personal income tax return that's due every year, right? Hopefully they filed the one last year, but not always. So you need to check and make sure they filed their prior years. You also need to file at least one, sometimes two, depending on when they die, personal income tax return, so your 1040s. So that's number one. Your responsibility as the executor, you have to get those returns filed. Number two, when you open an estate, or if you're settling an estate through a trust, the estate or the trust are their own tax-paying entities. So they'll have their own EIN number, their own tax ID number. And if they earn over $600 of income in a year, you have to file a fiduciary income tax return for that entity, for the estate and or trust. So that's the second bucket. We got their personal, we have the fiduciary returns for the actual entity. And the third is the one that applies to the least amount of people, but some, and that's an actual estate tax return. So right now, every individual has $15 million of exemption, estate and gift tax exemption that they can use during life or at their death. If the estate is over 15 million, you're required to file an estate tax return. Also, if the combined estate of the spouses is over 15 million, you likely want to file an estate tax return at the first spouse's death so that we can give the rest of their exemption to the surviving spouse. So it's called a portability estate tax return, a portability return. And so if you're at 15 million, close to 15 million, definitely a good idea to go ahead. There's going to be an expense to it because estate tax return preparation is not cheap, but it is well worth it. Right now we're settling an estate that's around 35 million. The first spouse died in 2014 and did not file an estate tax return for portability. The second spouse died last year with the 35 million. So well over 15 million, we're paying estate tax on everything over 15 million, or a little less for last year. But so we're paying estate tax. So what we've had to do, and it's a very expensive process and we're not 100% sure if it's going to work, we've had to submit a private letter ruling request to the IRS to say, hey, we know that the first spouse didn't file that portability return. Please, can we go ahead and file one and pull their estate tax exemption amount into the second spouse's estate so that they'll have more exemption. So if we're successful, we'll save them $2.5 million of tax. If we're unsuccessful, you know, it's a little up in the air. The IRS grants a lot of them, but not all of them. So that's your third type of tax. So we have personal income tax, fiduciary income tax, and the third one is your estate tax return. When you start to get near that 15 million, you're going to have to think about.
All right. Sounds like you want to have an estate that's under $75,000 at the end of the day, you know. And everything else goes directly or goes into a trust or something like that, right? That's what I'm hearing. No, kidding. Sort of. How long, generally speaking, how long does the average estate take to get settled in Virginia?
So that's a little bit of a hard question, right?
Yeah, I know.
Because
They're all over the board.
they're
right?
all
But,
over the board, right?
Let's just say a normal
estate.
no estate tax.
I'd say it's going to be between 1 and 2 years, right?
Okay.
Because you do have that tax filing obligation. And so if someone dies in June of this year, you don't even file their final personal income tax return until April, if you're lucky, of next year. So it's at least a year, and often more than a year. I'd say on average between 1 and 2 years. Some people, and you can kind of shorten things. So if things are very simple, we know what all the debts are, we've paid them all, right? We know who all the people are, everybody gets along, we've cleaned out the house, we've sold all the stuff. We can go ahead and make distributions to beneficiaries. It's not that you have to hold the assets back in the estate or in the trust. Like you can go ahead and make those distributions, and if you're working with an attorney, they might recommend that you have a refunding agreement that says, oh, if some other taxes come up, they agree to pay the money back, right? That's a protection for the fiduciary. So you can make distributions, or you can make partial distributions. If you have a $2 million estate, you make a partial distribution of $1.5 million or more than that even, and just hold back what you think you need to pay the final taxes and final expenses. So the process itself takes a while, but you can move forward and people can get their money sooner than that, right?
And what typically causes estates to be either delayed or even contentious in Virginia?
So one of the biggest things, and I was so glad that everybody here has a will, but one of the biggest things is no will. We're working on one right now where there was no will. There's two sides of the family that don't really know each other, don't get along. It's taken us over 2 months just to figure out who is going to serve as the administrator. So, and expense, right? Like that's not cheap. So just figuring out who is going to do the job. And I don't anticipate it's going to get much easier just because these people don't know each other and they don't get along. So no documents telling me who's going to serve and where the assets go. If people haven't filed tax returns, you end up with a lot of debt, and that can cause some problems. Tangible personal property is probably the number one thing that surprisingly causes the most contention because they're sentimental items, right? So everybody remembers that green frog on the counter that held the sponges, and everybody wants it. So like, it's not worth anything, but it's worth a lot to somebody, right? Mm-hmm. That sentimentality. So most wills that are drafted in Virginia contain the tangible personal property memorandum. I highly recommend, it's underutilized, highly recommend you use it. And it can help save a lot of arguments and a lot of headaches.
I have seen that just personally. That's the page that's usually blank in all the wills that I've looked at, right? Because the attorney says, this is where you list your tangible property. You want to make sure it goes, this specific thing goes to, and everybody's like, oh yeah, I'm going to do that. And then they put the book up on the shelf and they end up not doing it. So I think, if you've got that page in your will, go pull it out when you get home and think about who you want to have all the stuff in the house.
And ask people, right? Like if you think that nobody would want my stuff, ask them, right? And maybe they really don't, but if you've put it on the list, then they get it. And if you've asked them, you've put their name down, they get it, and there's no argument. So that's definitely one of the areas that I see the most contention.
Yeah. Generally speaking, how much help can an executor expect to get from sort of the estate settlement administration structure? Like you talked about the commissioner of accounts, right? And then they've got people that work for them in the courthouse. I think a lot of executors think, well, I'll just go there and they'll tell me exactly what to do and help me do everything. Is there truth in that? Is there, what can somebody expect?
I think, so in Virginia, each locality has their own commissioner, like I said. And each commissioner is a little bit different and operates a little differently. So you might find a commissioner in a western part of the state that, this is a tiny part of their practice. They just are doing this because somebody needs to do it. They don't have time to give you any advice, right? Like, they're trying to make a living, and this is just a small bit of what they do. And on the flip side, some of them are very nice and very helpful. And then you have some around in this part of the state that it is their whole practice. They are the commissioner of accounts, and they have no private practice. So this is all they do. They have a staff of auditors. And none of them can technically provide legal advice, right? So if you call them and say, I don't know who's supposed to get this stuff under this intestacy law, they're going to say, sorry, I can't tell you that. But if you say, hey, I can't figure out where to put this asset on the inventory, they might say, okay, you probably need to put it in section 1 or whatever. So it's going to vary from jurisdiction to jurisdiction, and some commissioners are more helpful than others, just like some commissioners are more of a stickler than others. Like, some commissioners, they just want to see that the job's been done. If it seems like you're missing a receipt or something here or there, they're fine with it. Others are like, you're missing this receipt. I'm not approving your accounting until I have that receipt. So I think if you have a general question, it's a good idea to call the commissioner, because it does also show that you're trying to do your job, right? They're less likely to hit you with a subpoena to appear before the court for failure to file your accounting if they know you're trying. So definitely call them. The response will be mixed, and just sort of depends where you are and who you're talking to.
Take them some cookies or something and maybe try
That's
to
right.
butter them up. All right, this is more of a basic question, but let's review this again. What constitutes a valid will in Virginia? What needs to be on that piece of paper or document? Mm-hmm.
So a valid will, man, every time I have a question like this, I actually go back to the statute and I look at it because I don't want to get this wrong. A valid will has to be signed by the testator and 2 witnesses who are all present at the same time. The testator has to request that the witnesses sign. The testator has to be of sound mind, has to know what their assets are, so they have to have testamentary capacity to sign that document. And so it has to be signed and dated by the testator and those 2 witnesses. In Virginia, we have a self-proving affidavit that says that all those things happened, right? So it's a second page or a second signature page at the back of your document that's an affidavit. It states all those facts that the testator signed. They're of sound mind. They're over the age of 18. They asked the witnesses to sign. Everybody was together and did it together. And then there's a notary block, and then the notary notarizes that affidavit and says, this is a valid will. So those are the actual requirements in Virginia, at least the first part. The self-proving affidavit is an additional part that can save you some headache if you can't track down those witnesses, right? You only need those witnesses if you're lacking that self-proving affidavit. If you've done that self-proving affidavit at the same time you signed your will, you don't need those witnesses to come to court with you. It's when we don't have that last page, that self-proving affidavit, that then we're tracking down witnesses, trying to, have them do a deposition saying that all the requirements were met.
Okay, did not know that. I had a follow-on question to that, and I can't.
What happens if the witnesses are no longer
Oh, that's a good question.
Yeah, you're in trouble. You might not have a valid will. Yep.
So people that go online and get wills made, they go to virginiawill.com or whatever, and they print out the documents. I'm assuming you're not a fan of that. I would not be a fan of that. You see some mistakes happen around those types of situations?
So, yes, lots. A lot of times it's in the execution, right? Some of them have okay provisions, but then they're not correctly executed. Either they don't have the witnesses. We had to go to court for one not too long ago that only had one witness that was an online will. But it had the affidavit. So they were missing a witness. We had to go to court and say, look, this is a valid will. Like that was their intention. And but it was expensive. They could have just paid the lawyer to do the will and paid a lot less. So a lot of times it's in the execution. Sometimes it's in the provisions themselves. They think that what they're putting in there makes sense. But when somebody goes to read it, it makes no sense, right? They kind of leave property to somebody to care for somebody else. Well, you've kind of set up a trust in your will then, but kind of not. So sometimes we end up back in court trying to determine what the terms are of the will. So even, I don't know, I am not a fan of online wills. There's good intention there. We're trying to save money, but I know for a fact that when you have an online will, it is going to be more expensive in the administration phase than it would have been to just go and hire an attorney.
Yeah, sounds like very good advice. So when somebody dies, obviously it's a time of there's a lot going on. It can be a rough time. What are some of the sort of classic or biggest mistakes you see families make in this estate settlement process, in that time period?
Yeah, I mean, I think I've touched on some of these. I think rushing is like one of the biggest issues because, again, you are grieving and you're trying to get through a process and you think you're doing well, but you're doing it the not simplest way. So, there's no need to rush. Like that is one of the biggest mistakes. Or just going ahead and qualifying when you didn't need to qualify. I think one of the biggest messages is to just slow down, take a little bit of time to get your path right, and then go. So, I think it's really sort of like just going all in gung ho, get it done when and that's just the wrong direction. I think those are the biggest mistakes. Sometimes we see mistakes where people will qualify because they need to, and that's the right thing to do. But then sometimes in the administration phase, they're doing things wrong, like they over-distribute. So they send out, all $1 million, and they have nothing left to pay the commissioner their fees or the taxes or whatever. So, sometimes we see over-distributions. We see a lot of things go wrong trying to file that accounting. Yeah.
How long is there a time frame that you have to actually kind of get started?
Not really. I mean, we sometimes have people come to us. My mom died in 1999. I just found this account, and we're starting probate in 2026 for something that happened 27 years ago. So, I think there's certain responsibilities that need to be handled in a timely fashion, especially on the tax side. But and I think also like it's really just protecting the assets. If there's bank accounts and somebody else has access to that bank account, you need to notify the bank and say, hey, they died, nobody should be touching these assets, right? So there's certain like precautionary protective things that you should do, but there's no like set standard like I have to get it done in a year or start the process in a year.
Okay. I think we're about done with questions. My last question would be, how many people here have used ChatGPT to look up things or try to find information or Claude or any of the other ones? How dangerous is that to do? How much should we, let's just talk a little bit about that, the AI side of this.
Yeah, so I think as anybody will tell you in any setting about anything that you're using the AIs for, it's all about the source, right? So if you get an answer and it's coming from the Code of Virginia, I'd feel pretty good about that answer. If you're getting an answer that's coming from some blog of some attorney that is a family law attorney, so doesn't do this kind of practice all the time, maybe not as reliable. If it's just some guy off the street saying, I think you should do this when you settle an estate, not reliable at all. So, right, so, I mean, I think it's, like I'll put something into Chat GPT just or into the AIs just to kind of guide me to the right code section or the just to simplify things. But I would always kind of dig in and check.
Verify, yeah.
And so I think it really is about the source.
Sure. So it sounds like we're going to wrap up here and then open up for questions. But it sounds like to me, I mean, this has been great advice. It's a situation that we're all going to be faced with, either naming someone, being an executor, or having a spouse or a family member who's going to come to us for help. But as the person with the estate, letting your executor know as much as possible up front, being as organized as you can be, documents, where are they, the titling and beneficiary update. And as most of you know here, we're big on that, getting TOD on most accounts and making sure the beneficiaries, we review those all the time. And then slowing down if you are the executor and going for help when you feel like you're not sure what to do next. I mean,
there you go.
Wraps it up, yeah. So with that having said, I'm sure some people have some individual questions. We probably got about 10 minutes to take a few of those, and then we'll go ahead and get you all out of here. So, Debbie.
I just want to, I'm in the middle of settling an estate, and I thought it's the third one I've settled and think, but the one thing I'll tell everybody, everything is TOD or POD on this estate, but one account I didn't have the full account number because the statements, they're truncated.
Mm-hmm.
I was POA on that account, but it doesn't matter once the person passes away. And the hoops I've had to go through without having the full account number is amazing. So when you put your assets together for your executor, make sure it has full account numbers.
Good.
I argued with them, but it's absurd.
Right.
Because I had the last four, I had a social security number.
Right.
I had the amount in the account. So that's just something. It's those little details.
Sure.
Get
Good. Good feedback.
For
For people on Zoom, what Debbie was saying was when you're putting together your book for your executor, make sure you've got full account numbers for all financial accounts that are out there, because if you don't, that custodian may not be as forthcoming as you want them to be in giving you the information you need.
little experience that I found was my mother, in her wisdom, wanted to name all three children as co-executors. What a headache that was. So,
Yeah, let's talk.
My sister lives in California, and trying to Excel stocks and deal with stuff on two different coasts was a nightmare.
That's a great point, and I should have brought that up. So the comment was, what if you have co-executors or sometimes three children named as executors, and how can that complicate things? So we'll let.
Yes. So generally speaking, if I'm doing estate planning, I advise against co-fiduciaries because somebody's going to be doing all the work. Somebody's going to get mad. They're never going to agree. Should we sell this? Should we do whatever? Having one person in control is usually the better approach. However, in Virginia, if all the beneficiaries are also like the fiduciaries, all the beneficiaries are also the fiduciaries, so also the executor or the administrator, if they have to qualify, we can sometimes avoid having to do that accounting process, the really annoying accounting process, by doing a statement in lieu of accounting. And so it's like a little shortcut if all the beneficiaries are also administrators or executors. So generally speaking, I'd rather have one. But if everybody gets along, everybody's in town, it's not going to be a big deal for everybody to work together. Sometimes I will suggest that everybody serve, just so that we can avoid that accounting. So it's a great point that, I don't want all that arguing, but at the same time, sometimes it can have a little benefit.
It's just, getting the green seal.
Yeah, the signatures, right?
Or whatever,
Yeah.
Yeah. If you got people in different locations, it's impossible to get the paperwork, or you're spending money FedExing things there and here and having to get signatures on it. Yes, sir.
Mm-hmm. Are there any concern or issue if you select an executive that's out of state?
So the
Yep.
question was, is there an issue with having an executor of a Virginia estate who doesn't actually live in Virginia?
The main requirement is that you have to have a resident agent appointed. So that's very simple. Our firm will serve as a resident agent for our out-of-state executors all the time. Sometimes some courts will require a surety bond if you're out of state. So even though your will might waive the surety bond on anybody who's serving as the executor, if they're out of state, there are some courts that do require the surety bond, and you have to purchase that through an insurance company, and it's a percentage, small percentage of whatever the probate assets are. So just an additional expense, but generally they can serve, just maybe some additional hoops.
Can't the will say, no surety bond required?
They can,
And,
but at the end of the day, it's in the court's discretion. So yes, and the question was, can't the will waive the surety bond? And yes, but sometimes the court will require it. Mm-hmm.
And the surety bond is there to protect the beneficiaries of the estate.
That's
correct?
right.
Okay. Ariel, you had a question?
Yeah, could you explain, I didn't quite understand, what is a self-proving affidavit?
Yeah, so
the question was, what is a self-proving affidavit, which was the document you need to avoid having to chase down witnesses?
that's right. So you have your will, and the last page of your will is the signature page where the testator has signed their name, and the witnesses have signed as witnesses. So that is a valid will, and it can be recorded. But in order to record just that, you need to track down the witnesses. So the self-proving affidavit is an additional page at the back of the will that sort of attests to all those things that make it a valid will. So that the testator was over the age of 18, sound mind, all that. He requested the witnesses to sign as witnesses. So all the requirements that make that a valid will are stated in that affidavit, and the testator signs again, and the witnesses sign again, and there's a notary that stamps that and says, yep, that's correct. So that affidavit saves you from having to track down those witnesses.
But you do still have to have two witnesses?
Correct, yes.
Okay, I got it now, thank you.
Sure.
Margaret.
If my children are not particularly savvy in estate management, what kinds of people or jobs or abilities make a good executor?
So the question was, if you have family members maybe that aren't people that you want to burden with settling the estate because that may not be their forte, what other types of people should you look at to name as an executor?
And so I think an executor has to be very detail-oriented and organized, and has to have the time and ability to make the phone calls to the financial institutions, the insurance companies, has to be able to appear in person to qualify at the courthouse, right? So not everybody can do that. Some people are very busy, some people it's not their strength, right? And so there are, other people that, it doesn't just have to be your children, of course. Like you may have a close friend or a nephew or a niece who may be more well-suited for it. And then there are professional fiduciaries that can serve as well. So a lot of the banks will serve as executor. Our firm is one of the very few firms that I know of that our firm will actually serve as the executor if you need it, right? If you have no other option and you think that's the best option, our firm can serve. And then some attorneys will also be willing to do that as well. And occasionally I'll see like a CPA or somebody named. So there are other professionals that can and do it, will do it very often.
It is something you want to review, and as Leah said, it's a great process or a great habit to look at your will every probably 3-4 years. I had a will done when I was much younger, and I named a parent, right, as the executor. Well, now I'm 60. It's not a great idea to have my 84-year-old dad as my executor, right? So I've obviously changed that, but so things change through your life, and you want to make sure that that person is actually going to be around who you've named for that. I have a question just popped into my head. So the $75,000 small estate question, what if the stuff that the person has, I mean, who decides the valuation of that so you can claim that you're under the 75? Everything else has a transfer on death or beneficiary or whatever. It's just the household assets, the paintings, whatever, in the estate.
So when you're filing your probate paperwork, a lot of times you just estimate, household contents, $2,000 or whatever. If we start to get into things that have more value, jewelry, those type of things, sometimes you might need to get them appraised. If it's for an estate tax return, you absolutely have to have it appraised. If you're trying to divide the stuff evenly, you probably need an appraisal. When we're talking about the $75,000, we go off kind of a best estimate, but there are times when the stuff exceeds the $75,000, especially you start throwing a car in there, or a lot of jewelry. We have an estate right now where there's about $400,000 worth of jewelry. We didn't even know about that, but once we realized that, somebody did need to go and qualify just to properly administer the jewelry, even though I can basically give it to the next person, right? Somebody had to go and qualify so that we're properly under the law. Somebody is appointed.
Right.
Yep.
So basically, there's some leeway, it sounds like, but you're trying to do just your best guess on that.
That's
Okay,
right.
Great. Oh, one more question.
So tangible property, if we can get rid of that before they pass? Because you're saying that this is gonna be a nightmare if I don't. You guys get so much
Yes.
stuff,
Yes.
We've already had those discussions of who gets what ring and who does this.
So the question was,
When she goes to assisted living, I grab the jewelry box and just take it home and it's mine. And distribute the stuff the way that she asked, the paintings or the.
So
the question is, if there's tangible assets in the estate that have a pretty high value, how can you get those out of the estate and get them distributed so you don't have to worry about probating them? What are the ways to do that?
So yes, tangibles tend to be like the most difficult thing, right, to administer, but somebody can definitely give them away during their life. If there's an agent under a power of attorney and there's the gifting authority in that power of attorney, and we're still acting in the principal's best interest, then potentially those could be given away using a power of attorney. There's some, that's fact specific. So the more though that can be given away, a lot of times when we see the tangibles not as complex is when someone has moved into assisted living and they've downsized and downsized and downsized and they're left with just kind of the bare necessities at that point. And then the tangibles really aren't an issue, and a lot of it gets donated, or maybe there's a few things get sold or somebody takes after the death. But to the extent, and also it gives people joy to give things away, right? So to the extent you want to give things to people, you're benefiting everything. You're getting it out of the estate, you're bringing yourself joy, you're bringing joy to the person who's getting it, and so it's great if you can dispose of it prior to death. I don't know if that answers your question.
It helps a lot.
All right, if there's no other questions, we'll give Leah a round of applause. Thank you very much. Thank you all for being here. I'm sure Leah will stick around and answer questions if you've got any offline. And the link, if you want to watch this again, the link will be up on the website in a few days. So thanks everybody for being here. Appreciate it.
Thank you.